Good morning, everyone. This is Jim Reedy from Sheehan Finney, and you are with the New Hampshire High Tech Alliance. This is the HR Exchange, and we're thrilled that you're with us this morning. Before we get started and get into our program, just a couple of quick announcements. Next month, March 10th, we will have Tracy Sponenberg from the Granite Group to talk about HR technologies, HRIS, and other technologies that help us perform our jobs better and more effectively. The remainder of the schedule is on our website for April, May, and June. In May, we are going to have our annual employment law seminar, as we've done for the last 33 years. With COVID, things are a little bit different still, so it will be virtual. It's a 2-day presentation, the Tuesday and Thursday before Memorial Day, so keeping with our consistent Thursday before Memorial Day. So that information will be coming on that shortly with save the date and registration information. So we look forward to you joining us there. This program is available for SHRM HRCI credits. You'll see that information at the end of JP's program. So data breach, it is a hot topic, and some of the collateral damage through COVID has been everything from mental illness, drug and alcohol abuse, to other issues associated with health and wellness, but also something that has been a sort of a collateral issue is data breach and related privacy issues. JP Harris, my partner, is a litigator by trade, but over the last several years has become I would argue, not only a regional, but beyond expert in data privacy and security. JP counsels clients large and small on issues related to preventing data breach and responding when one occurs. JP is here today to talk about that and related topics. Your questions, you can post them down below in the Q&A section, and there will be time to respond. So please welcome JP Harris.
Oh, thanks, Jim. I just wanted to mention, everyone, we're recording this seminar, and as Jim mentioned, please, I was hoping we'd be in a live room, of course, where we'd be able to have some more back and forth, but please type in your questions to the Q&A. I think we're going to hold them, I think, till the end, unfortunately, but we'll go through them. As Jim mentioned, I am a litigator. That's my day job. I have counseled our clients through data breaches and data incidents where, frankly, we had to analyze whether there was a breach, and we'll talk about that a bit. Part of that requires coordinating with cyber insurance carriers, and the lawyers get involved early in the process, usually to coordinate with information security professionals and forensic folks that come in to help figure out what happened and close off any breaches. So I sort of quarterback that process. There's obviously been some lessons learned from those incidents, and that's really what I want to try to pass along today. If we sort of work backwards from what happens in the event of a breach or an incident, you can take lessons from what other people have learned, what they've gone through, and prepare your own company or organization. So we're going to talk a lot about how to be prepared today to lessen the blow. I also really try to get companies to keep less data. If you have less information to protect, the fallout from an incident will be lessened. We're going to talk a little bit about the emergence of privacy laws, and the legislatures across the country are now really putting the onus on companies to justify the data they keep and how long they keep it. The days of keeping every transaction forever because you want to build up a customer database or for your sales teams, I think those are coming to an end. You've really got to sort of justify the data you keep and how you use it, who you share it with. So we'll talk about that. I act as the co-chair of our data privacy and security group. The other half of our team, if you will, is my partner, Doug Verge. So Doug handles the privacy and regulatory compliance portion of our practice. So he's on top of these emerging privacy laws. He counsels companies with respect to the rights that legislatures are affording to your customers or third parties, and helps companies make the required disclosures. But more importantly, how to actually implement these rights. So if one of your customers now has the right to be forgotten or or to have you purge data about them. Doug helps fashion policies and procedures tailored to you so that you can actually implement those rights. So that's sort of the other half of our team here. One disclaimer, this is just going to be a general presentation about some legal topics, and you should, of course, seek out specific advice for your circumstances. So to get ourselves rolling this morning, I have a few questions at the beginning that I'm hoping everyone will participate in. If you get every question correct, you get a free rest of the seminar, but you must be 18 years or older, and you must be present to win. Some restrictions apply. So let's go to the polls. Let's see if I can do this. The first question is, have fraudulent unemployment claims been filed on your employee's behalf? So if you've experienced that recently, give us a yes or a no on that one. I will tell you that if she and Finney were participating, we would have yes in this column. All right, and here are the results. So a little more than a third of this group. All right, we got another question coming up. Have fraudulent tax returns been filed claiming your employees' tax refunds? Give this another couple of minutes. We're getting into tax season. It's usually a time when I get these calls. A couple more seconds. All right, only a few, that's good. Hopefully that holds true this tax season. The next question. We have more remote workers today, and my level of confidence as to the security of data is higher than before, same as before, lower than before. We're going to spend some time today talking about the risks that have always been present, but they are certainly exacerbated when you have folks working outside your building. So we'll call this one. Here are the results. So about half of the group feels less secure than before. A couple more. Here's number 4. My company has conducted a data security risk assessment in the last year. Yes, no, or what is a risk assessment? We will spend some time talking about risk assessments today. So for those of you who haven't gone through the process before or are a little unsure about what that means, hopefully today you'll walk away. So that's great, 64% have done it. This is a great group. And last one for this morning. My company has a written program to evaluate the security capabilities of third parties that access our company's data. Yes, no, or please make it stop. All right, a couple more seconds. We got a few more people voting. Okay, so we're kind of split here on this one. So we'll, at the end of the presentation today, we'll spend some time talking about third parties. All right, so here's a little outline for today. We're going to talk about what happens in the event of a breach. There will be some slides to talk about what happens if your employees report to you that they've, or that you learn of fraudulent unemployment or tax filings. So we'll talk about some tips to handle that. I'm going to spend a little time talking about cyber insurance. Of the breach events that we have counseled our clients, only about half of our clients have actually had a real bona fide cyber insurance policy. And there are some folks that have sort of tacked on or free cyber coverage on top of a commercial general liability policy. And I think for reasons we'll talk about today, many of those clients find themselves to be underinsured. But the goal of this presentation will be to make you better consumers of those products. They're not uniform. And so we'll give you some ideas of things to ask your insurance specialists about. We're going to talk about risk assessments, which is really something every company needs to do these days. It's just part of corporate hygiene. It's necessary for regulatory compliance for many folks. but it also sort of feeds naturally into breach preparedness. And there's a side benefit that if you go through that process, I think it tends to lower your cyber insurance premiums because you're able to demonstrate to the carrier you are a lower risk. And we'll talk about vendors and third parties. So we're all sort of integrating our data. We're finding specialists, cloud providers, other software providers that are useful to our business or sort of tack-ons to things that we do. And it's a particular area of vulnerability because they have access to your system. And what happens if they have a breach? How is risk allocated between the parties? So we're going to spend some time talking about that today too. All right, this just came across the newswire. I think it was last week. The Federal Trade Commission is one of the federal agencies principally charged with monitoring data incidents, and Federal Trade Commission reported that they received more than 2.1 million fraud reports in the calendar year 2020. Consumers reported losing more than $3.3 billion in fraud. That's almost double from the year before. There were 1.4 million reports of ID theft. That's that's 2 times the amount from 2019. And about 400,000 of those 1.4 million reports involved the misuse of personal data to try to get a government benefit such as unemployment insurance. So Jim's correct. This is, we're not trending in a great direction on this. So the risks for everybody are going up, unfortunately. So I want to talk a little bit about some of the incidents that we've handled here to give folks a sense of sort of the breadth of the problem. We've sort of already touched on employees coming to HR to say someone's filed a tax return or sought unemployment benefits. We had one in the last year. We had a client that regularly pays subcontractors through ACH payments. At the beginning of the relationship, the client emailed off the ACH form. The subcontractor filled in all the banking information. Several months went by, 6 or 7 months, and the client received an email from the subcontractor saying, "I've changed banking. Here's my new form." It was exactly the company form with the logo on it and the whole deal. It was signed. And so for the next couple of payments, the client just changed the banking information and made the payments. Well, unfortunately, the subcontractor's email account had been hacked and someone had forged that form. It was exactly the client's form. The signature was not a great signature, so we got into a bit of a tussle about what's the standard of care for our client to sort of confirm these banking changes. So that was kind of an interesting one. Altered wire transfer instructions, that's been around for a long time. If you don't have a policy, a written policy where you're picking up the phone and calling a number to confirm wire instructions, you really should, because that's basically becoming standard of care now. We had an incident a few years ago where a client was an online retailer and someone had stepped in between their website ordering and the credit card processing for orders, and was just siphoning off credit card information for months. And that triggered the requirement to make notifications that we'll talk about in almost every state. But it also required us to get lawyers involved from 10 countries. So we found lawyers in Ireland, South Africa, all these countries to get advice about whether notifications were required in those countries. And also sort of a thing to note, if you do business in Canada, one lesson we learned there is that each province has its own sort of rules and statutes, which is not unlike what we're going to talk about for the United States. Of course, we've had the incident where a spoofed email was sent to the HR department calling for the transmittal of all the employees' W-2s. So that we've had that. We had one about a year ago where the company switched payroll vendors and they sent out emails to all the employees saying, "Hey, we've moved to such and such payroll provider. Here's the website you need to go to. Here's your default login credentials. Go to that website, log in, change your password to something unique." And one of the employees was a little slow In doing that, their personal email account was hacked. The bad guys went in and created their own login and banking information and redirected direct deposits, which was a problem in and of itself. But the individual used their personal email account for work purposes too, and this had this cascading effect of having to investigate with forensic folks whether there had been any compromise of any of the business systems. So it turned into a much bigger project. Luckily, there was no compromise of the business systems, but we had to investigate it. The last one on this slide is a bit unique. We had a not-for-profit client that over the course of a weekend received hundreds and hundreds of sort of $5 donations, all by credit card. And it turned out that there was a bank in South America that had been hacked and all these new credit card numbers had been disclosed. So the bad guys were testing the credit card numbers to make sure they were right. And somehow they picked this not-for-profit in New Hampshire to make donations on an online portal, which sounds great at first. The not-for-profit gets all this money coming in, which of course they had to return. But the real problem was the not-for-profit incurred all of these bank charges by the bank to process the credit card payments. So we had to deal with that. I haven't even mentioned on this slide ransomware, which is really the new or most prevalent trap these days. For those that are unfamiliar, ransomware is, generally speaking, somebody clicks on a malicious link and or there's otherwise infiltration into the system, and the bad guys encrypt all of your systems so you can't do any business, and they require you to pay in order to get the key to unlock your system. The new trend, however, is because companies have been getting better about having backup systems, which sort of negates the encryption. They also threaten to disclose all the data. They take some data out and they threaten to disclose it, which causes reputational harm and triggers all these notification requirements that we're going to talk about. So that's kind of the new trend. We'll talk about how to deal with that. Another one that came up very recently was this sort of Robinhood scheme where there are hackers that are, holding other companies ransom. They're collecting money, and out of the goodness of their heart, they made a donation to a charity. So that's sort of the Robinhood part of it, stealing from the rich and providing to the poor. Of course, the feds, the U.S. Attorney's Office in San Francisco, I think it was investigating the hackers, and so and our client didn't want to keep the proceeds of some criminal enterprise, so we had to coordinate with the feds about turning over those funds. So if you see a strange donation come into you, be wary, because it's not quite as straightforward as just keeping the money. So hopefully the lesson from those couple of slides is that no one is immune. We've had large companies, small companies, not-for-profits, really any industry. The reality is that Social Security numbers held by not-for-profits are just as valuable as Social Security numbers held by anybody else. And ransomware is particularly inexpensive. There's a black market. You don't even have to program your own ransomware. You just purchase it online and then you deploy it and you collect the money. So no one is immune. There's really all kinds of data that's useful to the bad guys and has some monetary value. So you all have, Social Security information and benefits information, some health information related to your employees. Some of you have customer data, and you have some company data that's also valuable. I think the most recent ransomware event we dealt with actually involved valuable company information. They had secret information that had been encrypted and that was threatened to be disclosed. And that information was confidential to our clients' customers. So they had to navigate their way through that. So there is an inevitability, but I'm not, the sun's out today and we don't have to shovel any more snow today. So this is not all doom and gloom. It doesn't have to be disastrous. And there are steps you can take to at least reduce the likelihood and also to sort of lessen the pain. But there are really two large components to this, and you can't ignore either one. There's certainly a technological component, and I am not expert in that by any stretch. You have to have really good qualified IT professionals in your life. these days. That's just the cost of doing business. There's a difference between managed service providers, those that keep your printers running and, you know, keep your internet access alive, and maybe even do some monitoring for security. There's a difference between managed IT providers and information security professionals. And if your organization is complex enough, you may actually want to have those roles split. In other words, the people responsible for keeping you safe, on a day-to-day basis, the managed service providers, you know, you might want to have somebody else in your life routinely checking out the quality of those services, and that would be an information security professional. They're two different roles. And look, the reality is you can spend all the money you want on firewalls and AI to, you know, monitor intrusions and all that, but Bob in accounting could be your weakest link. And if you don't have a robust training program to help your employees spot problems, if you don't have a culture to sort of reward or induce people to come forward with suspicions immediately, then you have a real problem. This is only exacerbated in a remote work environment because whereas you used to have people coming into your office and you had, you know, it was a bit more business-like. Now you've got, you know, Sam working from home trying to navigate the perils of second grade with his son or daughter, and, you know, working hopefully from a dining room table or a couch somewhere. And, you know, Sam's using his personal Wi-Fi router that still has the default password from when he took it out of the box. You know, all of these vulnerabilities are important and need to be governed. So you need to have a real good partnership with your IT folks. That's not even really to account for the fact that, you know, we have refrigerators connected to Wi-Fi that have no security to them, and there's no firmware updates or any of that good stuff, or the thermostats are all connected to the Wi-Fi system, garage door opener, you name it. There's just a lot more vulnerabilities into the system. And if you've got these remote workers, you've now sort of inherited all the vulnerabilities of their home systems as well. All right, so we're going to talk a little bit. This is, I think, hopefully the last really bad slide for the morning. This is sort of the exposure, the types of exposure that you can face in the event of an incident or a breach. You may have statutory or regulatory exposure if you're in a particular industry. So if you're in the healthcare industry, for example, you know, you have regulators that have imposed requirements on you to protect and safeguard the privacy of health information. And there are penalties associated with non-compliance there. You could be in some other regulated industry that might carry its own, you know, financial industry, for example, might carry its own financial penalties. We're going to spend some time about the requirements of providing notice. So the days of, you know, having an incident and sweeping it under the rug, those are gone. Every state in the United States now has some notification statute, and failure to provide proper notification can itself result in a penalty or a fine. There is also regulatory exposure for failing to safeguard. So the Federal Trade Commission, for example, if you pay any attention to the news report, the news events that they publish on a weekly basis, every week they're fining somebody for failing to safeguard. And what's notable about that, I think, is it's really kind of tacking on, right? These are folks that have already gone through a breach event. They've already incurred all of this sort of you know, harm associated with dealing with that event. And then you've got the FTC coming on top saying, hey, you've got to pay a fine because you failed to safeguard. The other thing the FTC is looking out for is companies that misrepresent the extent to which they secure their data. So if you haven't checked your website in a while and you've got a privacy policy that promises, hey, we do this and this and this to protect your data, we don't sell it to anybody, we don't share it with anybody, and that's out of date, the FTC is imposing fines for misrepresenting to the public what you do with the data. So that's also sort of another tack on. There are, of course, the possibility of third-party claims. So if you had an incident and you exposed credit card information or social security information these folks theoretically have claims, and you need to be able to defend yourself against those. By the way, that's really kind of the underpinning of the notice requirements, that legislatures want you to provide notice to folks so they can protect themselves. That's kind of the hallmark of it. But these claims exist. They frankly have had a difficult time in the court systems. Almost all of the class actions have had a real difficult time. In fact, I think last week there was an appellate court in the western part of the country that dismissed a class action because folks, number one, have a hard time proving causation. You never really have the bad guy that stole the credit card information to take the stand, right? Those folks are sort of, they're almost never known. So it's not like you can go to trial and put up the person that did the hacking and explain, yes, I received this information and I sold it to so-and-so and they opened a new account. So there's a causation problem. The other sort of related problem is that our personal information is everywhere. I mean, my employer has my information. We buy stuff from Amazon all the time. They've got credit card. It's just hard to prove that any one particular source was the leak that led to the harm that I'm alleging. But there are some courts that are recognizing some damage theories that have allowed these class actions to sort of get off the ground. Courts recognize that it's a real hassle to try to clean up your credit if there's a fraud problem. And so courts recognize that you might incur expenses, but frankly, on an individualized basis, those are pretty low. The last one here is reputational harm, and this is something that really can be devastating. The statistics on companies that go out of business after they have an event like this are staggering. And that's not anything that's going to be covered by insurance. If people stop coming to your business because they fear that their data is not safe in your hands, that there's no insurance policy that's going to pay for that. All right, so let's talk about what happens if you possess data about people that live in New Hampshire. Notice that's not really all New Hampshire companies. You could be in Massachusetts but have customers or employees in New Hampshire, or you could be in Idaho and have customers in New Hampshire. This is the law that applies to protect the people who are the residents of New Hampshire. It certainly applies to anybody doing business in New Hampshire. But what triggers it is the misuse of personal information. And you have to comply with the notice requirements if misuse has occurred or is reasonably likely to occur, or if you can't rule it out. And that's the part I really want to talk about. There's basically a presumption of harm unless you have factual circumstances that give you a strong indication that there's been no actual misuse. You have to provide notice as required under this statute. For those of you in the healthcare space, you know that HIPAA has a similar sort of presumption. There's 5 or 6 factors that you have to consider in the event of a breach. If you can meet the entire test and sort of disprove harm, then you can avoid providing notice. But understand there's risk, and we spend some time counseling our healthcare clients about that. But the point here is, on most facts, you can't rule it out, and you're going to have to do what we're going to talk about in the next few steps. Now, not all data is protected by the New Hampshire statute. There's really a formula. It's really a combination of first name or first initial and last name, plus one of the things you see on the screen here. So it's first name, last name, and social security number or driver's license number. And you see the account numbers there. So if you had a long list and it's names and addresses, and that is stolen, that does not trigger the technical definition of a breach under New Hampshire. There might be other reasons, however, why you still would want to provide notice, business reasons or otherwise. But what you also need to know is that there are some, we'll talk about this wave of new privacy laws spreading across the country. And those laws, if they apply to you, often require that you identify and describe the types of data that you retain and how long you keep it and what you're going to use it for. And so even if name and address might not be a technical breach under New Hampshire, if you sort of disclose to people that that's the data you keep, you may essentially be setting a standard for yourself with your privacy policy that requires some further notification, even if it isn't to the sort of letter of the law under the New Hampshire law. There is an exemption under New Hampshire law for encrypted data. So that's one takeaway, that if you can encrypt your data and the encrypted data is stolen, then under the New Hampshire law, you don't have to provide notice. And there's a definition to encrypted that's up here on the screen. For those of you in Massachusetts, there's also a specific definition of the sort of level of encryption. This is, again, a key partnership with your IT folks. You have to figure out whether you can sort of successfully navigate the business environment with encryption. There's different types of encryption, right? There's encryption at rest, which means that the data that sits on your servers is encrypted. And there's also encryption in transit. So as you communicate back and forth with employees or remote workers or third parties, if you can encrypt it as it's moving, that's also helpful too. But the takeaway here is, if you invest some time and certainly money in the technology to encrypt your data, and that data is taken, and the key remains, the key to unencrypted data remains protected, then you actually don't have a technical breach under New Hampshire law. By the way, we're going to talk about this in a minute, but not all states are uniform in this regard. As I mentioned, Massachusetts has a specific standard, so you might have data that qualifies as encrypted under New Hampshire, but it wouldn't qualify as encrypted in Massachusetts if you didn't meet the technical definition. All right, so for personal information in New Hampshire, which is what we've been talking about, the sort of name and social security number or account number, note if that information is not encrypted and it's exposed and you can't rule out misuse, then you have to notify all the people on that list. So if you've got a big long list of customers, or if it's been months and you didn't notice this problem, right? The statistics show that retailers usually take months before from the time of the intrusion until it's detected. So obviously every day that passes, there's a possibility for more data to be left. So your list of people you need to notify grows. In New Hampshire, you have to provide written notice to those folks. You also have to provide notice to the New Hampshire Attorney General. And if you're in a regulated space, you have to provide notice to your regulator. There are specific contents of the notice that we're going to talk about in more detail. Those are fixed by the statute. If you happen to have more than 1,000 people in New Hampshire affected, you also have to provide notice to the credit reporting agencies, the 3 agencies. By the way, that number, that threshold 1,000, is also different in states. Some states it's 500, some states it's 1,000, and normally it's really only the number of people in that state. So if you have kind of a nationwide presence and the standard in Illinois is 500 people, if you have 467 people on your list, then you haven't met the threshold to provide notice, but you might have to the credit bureaus, but you might have to provide it because you have 1,500 people in California, for example. All right, there is a private right of action. So what that means is, under New Hampshire law, if a New Hampshire resident suffers damages as a result of your failure to provide notice or to protect their information, there is a private right of action that does include costs and attorney's fees. The Attorney General is also empowered with enforcement, and that office can assert fines and penalties up to $10,000 for each violation. I don't think it's really been tested yet as to whether that's $10,000 per person on your list or per event, but it probably depends on the severity of the non-compliance. For those of you in New Hampshire that are a healthcare provider or a business associate, there's a separate statute that applies to medical data. Again, there's notice to affected persons. There is a damage provision for those New Hampshire residents as well. And there's a HIPAA overlay. We talked about this. You have to provide notice to the feds. There's an online portal to do so, and they may come back and investigate the incident themselves. All right, I've touched on this a little bit. The real problem from a lawyer's perspective, and the real cost, one of the real cost drivers, is that the laws of the states are not uniform. We do not have an overarching federal general privacy law that preempts all these state laws, and there are nuances between them. So one of the things that the lawyers have to help you navigate if you have an incident is surveying all the states that might be involved and figuring out all these little nuances to make sure that you comply with the specific requirements in those jurisdictions. So if you have employees in New Hampshire, Maine, Massachusetts, and now you've got remote employees in North Carolina, who you've let sort of move away to care for family or go back home or whatever, you're now got to be mindful of what are the North Carolina requirements if our employee information is exposed. About half of the states do not have specific content requirements for their notices, so that's certainly easier. But there are differing definitions of personal information. So that little formula I talked to you about, name and social security number under New Hampshire, that's not uniform either. In some states, it's a different sort of formula. The states also have different definitions of breach. Some states have this presumption of harm that you've got to navigate your way, and others don't. So you might find yourself in a circumstance where you've had a breach, as the term is defined in North Dakota, but in Minnesota, you don't meet that level. So you're providing notice to the people in North Dakota, but not Minnesota. It's a weird exercise, but unfortunately, that's sort of where we are. And I should say that if you're going, let's say you do have a pretty widespread event, and you're providing notice to hundreds and hundreds of people in several states, there's certainly business reasons why you might want to provide notice to others, even if you don't meet sort of the technical definitions. You need to maintain these relationships, of course. And you want them to mitigate any harm they might suffer. So you might still provide notice. And sometimes there's this tricky balance where we help clients customize a voluntary notice, if you will, without trying to concede that we fall under the technical definitions of the statute and all that flows from that. So that can be sometimes an interesting sort of drafting exercise. Some states, as we've covered, require that you you provide contact information for the credit bureaus, which is probably good to do anyway. Some require that you provide contact information for the state's attorney general's office. Many AG's offices now have online portals where you can report your incidents online. Some require that you provide contact information for the FTC. There's a couple of states that require you use the word vigilance, for example, or we recommend you are vigilant in monitoring your credit. Some require that you advise folks to file a police report. So there's all these little nuances across the state, and that's where you need to get some legal advice to make sure you comply. Some require that you provide instructions on placing a credit freeze. And that in Massachusetts, for example, if a social security number is compromised, you must provide credit monitoring at your cost. So we've actually had one or two incidents where, let's say there's 500 people on the list, half of them, their social security numbers were compromised, half of them there weren't. So we provided one notice to the people whose social security numbers were not involved, and a different notice to the people whose social security numbers were involved. So that we're going to talk about credit monitoring. I can give you some insight as to how that mechanically happens in a bit. Some actually dictate the method of delivery. Some have, like California and Massachusetts, I think, have specific requirements that you have these specific headings in your letters. So this gives you a sense of the kind of patchwork that we deal with. So here's sort of the steps. These are almost in the order. Your circumstances might dictate a different order, but these are almost in the order that you would follow in the event of an incident. And so here's my sort of hint. If you don't have a data breach preparedness, a data breach response plan. This is really kind of the outline for that. One of the first things you want to do is notify any cyber insurance coverage carrier that you might have. And the reason is you don't want to blow your coverage. If you take steps that prejudice what they want to do without getting their permission, you do that at your own peril, and they might disallow those costs. So having your carrier's information handy, so you don't have to dig through files to find it, that's one of the first things to do. If you do have insurance, they will be able to connect you with experts. This is, in exchange for your premium and your deductible, you get access to some of the finest forensic security firms in the country, and they can augment your IT staff. And so you really ought to consider utilizing them. But if you have a problem, they get you these experts, they swoop in, a lot of it's done remotely. They want to look at your logs and look for vulnerabilities, but they swoop in, they help you analyze the situation, determine the extent of it, close off the leak, and collect evidence that you'll need. So you can utilize the experts provided by your carrier. That's what you pay for. But if you don't have insurance, you want to at least know somebody in the area that you can rely on for these services, and you want to know who they are in advance. You don't want to be cold calling people. Notifying legal is important. Having a lawyer involved to quarterback all of what we're talking about increases the chances you can cloak the response in the work product privilege, which would mean that if you do have claims come at you later, you'd be able to actually have some privileged communications with your lawyers and not have to share all of the inner workings. I think we've already sort of touched on the notification requirements often require legal help. Notifying law enforcement is also frequently prudent, so your plan should have the contact information for local police. At the federal level, the two agencies you normally reach out to are the Secret Service, of all things, and the FBI. If you have some kind of financial transaction, a wire that went to the wrong place or something like that, you have to act extremely quickly, but it is possible for the FBI under certain circumstances to claw back those payments, but it's got to be real rapid notice. But your plan should have the contact information for these folks. And then obviously you got to work to notify employees, even if it's not their data. Certainly if it is their data, you want to let them know, but you've got employees that are going to need to help you with the response, but are also going to start fielding questions. You might want to have in mind a PR consultant. This is another area where your carrier actually will pay for some of these services. If you've got a good policy, they'll help you get a PR firm to help you message to the public what's going on. And it's not quite PR, but there's sort of I think of it as kind of a related task. If you have a massive breach, your carrier will also help you set up like overnight these call centers where if you know you're going to be fielding a lot of calls, they actually help you with phone lines and bodies to take the calls, take down the information, and help you navigate through that process. And the sort of last thing is you've got to identify somebody who's going to be the point person to answer questions and sort of be the face of the organization. So hopefully this is helpful. This is a kind of an outline of what I think are really kind of the key ingredients to a response plan. Now, this slide is really kind of the key factual elements I think you need to collect as the event's going on. These are things that feed not only into the steps you'll take to respond, but these are really kind of what the lawyers need to know for the contents of the letters that need to go out and kind of to help you chart that course. So when I craft these response plans for clients, we have the information we just talked about on the previous slide, but I also try to leave some blanks so that people can collect this kind of information because these are the questions I'm going to be asking. We want to know the number of people affected, right? We want to get a sense of the volume. How big of a deal is this going to be? The time period for the leak. So again, most instances go on for months before people realize there's a problem. So we need to know the time period. The number of states and countries where the affected people reside. This, as I mentioned, is the big cost driver because you need a different letter for Idaho than you need for California, than you need for Massachusetts. So we need to know the number of states. And if there are other countries involved, we need to know that as quickly as possible. You need to be able to describe the types of information that's exposed. So if there are social security numbers, you need to be able to tell people your social security number was impacted. If it was private health information, you need to be able to say that. When you get these information security forensic folks swoop in, they're great about scanning your systems, and they generate for the lawyer this very detailed spreadsheet that has all these categories of information. We know exactly what was taken and who it relates to. You need to consider credit monitoring and credit freeze. So let me pause and just make sure everybody understands the difference between those two. Credit monitoring is the report you get once a quarter that says this is the activity on your, basically on your credit history. You receive it after the fact, right? It's retrospective. And it's a good tool. It tells you can find any suspicious activity, but you usually will not be alerted until after the fact. A credit freeze is a notice to the credit bureaus not to allow the opening of any new credit without going through special steps to confirm your identity. And so that prevents any new accounts from being opened. It also means that if you want to access credit, you have some difficulty. If you want to buy a new car or whatever, and you're sitting down there, you're going to have to quote unquote thaw the freeze. And there's a small fee associated with thawing the freeze, but that, as it sounds, you basically let this new account open and then you go back to the freeze and you won't let other accounts. So there's a little bit of an administrative hassle. The credit freeze issue requires you to be in contact with all three credit bureaus because, vendors out there might have a deal with TransUnion, and so they're opening an account, checking your credit with TransUnion, but they don't do Experian or Equifax. You'd be surprised. We'll talk about credit monitoring for a minute. So if you have a breach event and you have to provide credit monitoring or you choose to do so, normally that cost is absorbed by your cyber carrier. So that's another sort of selling point for these policies. By the way, I don't get a kickback on any of these insurance policies. It's not like I get any benefit out of it, but we're really trying to beat the drum to make sure our clients get these policies. You wouldn't avoid having a commercial general liability policy. This is really something you need to look at very carefully. But so if you have insurance, they will pay. And here's kind of how, and if you don't, by the way, you can still go to a vendor and get these credit monitoring services. It's really not that expensive. The last uncovered one we handled, I think it was $10 per person per month or something like that. But so the mechanics are this: there's a vendor that has, I'll give you an example. This one has a deal with TransUnion. They provide you with a website that you forward effectively by letter to the people you're providing notice to. And they have to go online and enroll themselves in this credit monitoring protection. You can't enroll for them. They got to go on by themselves. The letter that you send out has two things. It has a unique code for each person. So their letter says you go to this website and here's your, I don't know what it is, 8-digit code, whatever it is. And then there's also a special code that is just for your company. And there's a dedicated 800 number so that if they have any problems, they call that number. But in order to get anywhere, they need the code that matches up with your company. It's a sort of a way to legitimize their inquiry. And they go online and they enroll. You'd be surprised how low the uptake percentage is. I think I heard once the stats are if you have an employee related, let's say your employee W-2s are compromised, that there's like 10% of the employees that you offer this service to actually go through the process of enrolling. And if it's consumers, like people you don't have a sort of day-to-day interaction with, the uptick rate is far less than even 10%. So the actual cost of providing this benefit turns out very frequently to be quite manageable. And it goes sort of a long way, at least on the managing the reputational portion of it. So anyway, there's credit monitoring and credit freezing. You may have to provide it in certain circumstances, but not all. So the task really is to provide this template letter. We do one for every state, and then it's basically a mail merge operation. A lot of the good insurance, they pay for the paper, the postage, the whole deal. There's a question mark here about providing email notification. Some statutes allow you to provide this notice by email if that's the way that you regularly communicate with folks. I'm not a big fan of it, except to say that if you've got an incident, I am in favor of providing a sort of informal email notice to be followed up by the more formal notice so that you get some notice out to folks as quickly as possible. But the reason why I'm not a big fan of the email part of it is I want you to be able to have some kind of record of delivery. And you can do the read receipt portion, but we generally have people send it out to be able to track when you've delivered. So in addition to the template letter to the individuals, you've got to send, in some instances, you've got to send notice to the AG's offices and other agencies. And then, as we say here, you track the receipts of the letters so you can prove when they were delivered. You preserve any other evidence, and you await possible claims. And again, the reason why you send this out is because you want to basically establish a mitigation defense that if people fail to take proper measures to protect themselves after they've received notice from you and they suffer some harm, you'd be able to sort of defend yourself and say, well, that was really not our fault. You could have taken steps to protect yourself. All right, here's our, as promised, our little tip about false unemployment claims. There are things employees can do, but let me pause here. If you get one or two employees come to you and say, hey, I got this notice in the mail from Unemployment Security, someone's tried to file a claim on my behalf. It's helpful to give them this advice that we're going to talk about so they can protect themselves. But if you get one or two, it probably does not really reflect that your company is the source. But if you get a whole rash of these folks all coming to you, then at some point you will have triggered the obligation to do an investigation to figure out if it's been your systems that have been compromised. So where that magic threshold is hard to say. It's different for different circumstances, of course. But I just wanted to let you know that if you've got a whole bunch of people coming to you, you may need to hire a forensic person or at least do some investigation into your own systems to make sure your systems have not been compromised. But here's some things that folks should do. There is a website here on the screen to report fraudulent claims. Both the employer and employee should do their part in that regard. Filing a police report is recommended. It's not that the Exeter Police Department is going to put a whole team on it, but if you do suffer some harm, you want to be able to go back and say, hey, I at least reported it to the police. It helps if you do have some kind of personal cyber insurance tacked onto your homeowner's policy. It might help actually trigger that coverage. Obviously, you want to have people change their passwords on all accounts. That includes home and work accounts. So you ought to sort of mandate, if you have the IT department ability to mandate that folks change their work passwords, they need to do that, but you want them to change at home too. And I think it goes without saying that they should not have the same passwords for anything personal as they have for work accounts. Again, you can give them the information about obtaining credit reports and credit monitoring and credit freeze. I think if an unemployment claim has been filed, that means somebody has access to the Social Security number. And I don't think there's any real question that you should get a credit freeze. The one at the bottom is the one that I think people miss sometimes, and that is notifying the Internal Revenue Service that you've been the victim of an ID theft. And they will give you a PIN so that when you file your tax returns, you have to file, you have to include this PIN to be able to file. And that just prevents somebody from filing a tax return and claiming a refund. All right, let's talk about ransomware for a bit. So again, this is bad guys encrypt all of the company's data. And the real question there is, from a mechanical level, is your backup viable? Can you restore your systems and you don't need to pay the ransom to unencrypt your data? Obviously, your backup needs to be physically separated from your main system so that your backup's not encrypted. And the key here really is to practice. Do you really know how long it takes to restore your entire system from a backup? Can you actually do a full restore? How much downtime will you really have? is your backup really viable? So this is another hint for your breach preparedness plan. You need to basically have a schedule where you're testing how long and can you actually restore. Question mark really is, does your backup extend to all of these remote workers? Have you provided the facility, the technological facility for them so that they're not saving stuff at home, and that whatever you need backed up is, they're accessing your service through a VPN or some other remote access, such that they're not saving your data at home? Is the backup, in other words, truly encompassing all the tentacles of where your data is? We talked about that trend. There's a threat to disclose your data. The last thing I want to say is they don't take checks, right? They don't give you a PO box to mail a check to for the 25 grand they want to release your data. So you have to have access to cryptocurrency. If you don't have a Bitcoin wallet, you're going to be scrambling to figure out the mechanics of actually obtaining Bitcoin to make the payment. It's another reason to have insurance, because they will handle the Bitcoin process and payment. One little side note, the Treasury Department recently has been coming down on insurance carriers who just pay these ransoms, because there's a notion that they're making payments to countries that are on the banned countries list, the terrorist watch list, or what have you. So it's a little unclear how much the Treasury Department is really going to enforce these rules, but they did send out a communication to the carriers telling them that it's theoretically possible to be sanctioned for supporting terrorist countries or countries on the banned list. So that's really not so much a problem for the little guys, but you might run into a little bit of a difficulty with your carriers moving forward. Hopefully not. We've talked a bit about cyber insurance. There is a significant difference between standalone cyber coverage and what's sort of tacked on, or quote unquote free coverage provided with your other policies. The policies are not uniform. You really need to have a good insurance person in your life to help you negotiate any unique changes. Let me talk a little bit about that process. So from what I've seen, you get a very robust application for cyber coverage where they ask you all kinds of questions about the types of data that you possess and what volume, what kind of business you do, what you've done to protect it. Do you have a breach response plan? Do you have a privacy policy? Who's your IT provider? What's your schedule for patching? All that good stuff. And the better you fill that out, the more responses you have to those questions, actually the lower your premium. They judge you to be a lower risk than someone who's basically responding, I don't know. But what occurs to me in this remote environment is that you have obtained coverage based on representations of certain levels of security. And are you really certain that those representations are still true with all your remote workers? So just be careful. Obviously, if they give you coverage, that application becomes part of the policy, if you will. And if it turns out you have an event and your responses are not accurate, the carrier may actually find a way to decline coverage when you need them most. So you got to sort of revisit that application and make sure, again, if you've got all these remote workers, that you're still actually doing what you said you were going to do. The cyber coverage covers these things that we've talked about. You get these great information security experts, the legal costs, PR, and ransom, including access to cryptocurrency, and also claims coverage. So if there's a third-party claim, they will cover the defense and those costs. So you have to ask yourself, how much coverage do I need? And that really is a function of how much data you keep and what kind of data you have, how sensitive it is. You can kind of project out, how many states might be involved, what the harm might be. But that's an interesting exercise too, to try to figure out how much coverage you need. All right, so I want to talk a little bit about risk assessments. This is really an exercise that I think all companies should go through. It's a combination of all these factors that we've talked about. It's legal, your IT group, and your insurance. And I left off here your business people, but of course you want to find out operationally what the exposure is. One of the key steps in this risk assessment process, let me back up. The goal of the risk assessment is to identify any vulnerabilities, to figure out where your risks are, and then come up with a plan to deal with them. It doesn't have to be, hey, we've identified these 6 problems and we need to fix them this month. Doesn't have to be like that. It's, we've identified these 6 problems and we've got a 2-year plan. We have to make some investments this year. We can make some investments next year. Part of it's training. We're going to implement a training protocol where we're going to schedule training every 3 months or 6 months or whatever it is. It's more of a long-term sort of vision. I think a lot of folks are afraid that they're going to create this long document that's going to identify all these problems, and we're not going to be able to afford any of the fixes. And it doesn't have to be an immediate investment. Having legal involved in the risk assessment helps, again, try to cloak some of this in the privilege so you're not creating a document that later creates more problems. But there's also another reason for legal to be involved, and that is we want to identify any policies or procedures that you need to round out your compliance. And there's sort of 2 components to getting off the ground with that. One is a data mapping exercise. So what data do you keep and where is it? Who has access to it? How long do you keep it? Do you really need it? And the other sort of legal part is what laws apply. That's not as straightforward a question as you might think. Do you do enough business in California such that you're subject to the California privacy law? Do you have a presence in Europe such that you're subject to GDPR? The answer might be no to that. Well, it's useful to just, do you collect any data on people in Europe? Do your cookies on your website, do they collect data on people in Europe? That may be, and if that's the case, then you need to at least analyze what your risk is. You may decide we don't do enough business there, that I'm not going to do full-blown GDPR compliance, but you at least need to have a conscious discussion about it and make a decision about it. And again, this risk assessment will help you identify the level of insurance that you might need. And again, if you go through this process, oftentimes it results in a lower premium. Here's a little more detail about what a risk assessment involves. You can hire folks that scan your network and actually will identify for you where the personal information is kept, that you've got an old printer from 6 years ago you thought no one was using that's still connected to your network that nobody's updating. Look at all these entry points into your system, what's encrypted and what isn't. That's kind of the useful foundation that the IT folks do for you. Testing backups we talked about. Physical security is also a component. That's kind of outside the scope of today's presentation, but how easy is it for somebody to just walk into your environment and get access to your systems? All right, a little more that kind of comes out of the risk assessment and also sort of dovetails with the general theme for today is generating a data breach response plan. And what I want to talk about is what's in parentheses there, the tabletop. That's really an exercise where you bring around the key people that are going to be responsible in the event of an incident, and you take half a day and you pretend, okay, our system's been encrypted, we have a ransomware event, what do we do now? And you just march through who's going to do what and what the response is going to be, who's calling insurance, who's got access to the cryptocurrency, who's working on the backups, who's notifying employees. You just do that. It's also important, we mentioned this a couple times about employee training, and the training these days, again, has to extend to their home life. If you've got remote workers, you've got to give them some help about not using the default password on the router at home, updating firmware on routers and printers and all that good stuff. Are they using their home computer to access this stuff? Is that the same computer that the first grader needs to use for remote learning? All that stuff. Record retention is, I think, more important than it was even 5 years ago. If you don't need this data, you got to get rid of it. You'd be surprised what you learn from the information security scan, that you do have nuggets of data held, in folders on the server that nobody ever touches anymore. But as these privacy laws emerge, I've mentioned this a couple times, you need to actually disclose to people, the public, what data you keep and what you're using it for and how long you keep it. And you're basically being put in the spot of having to justify what you're keeping. And so that exercise, I think, is useful for the business folks to really come forward to the company and say, hey, I really need this information for these purposes. Okay, we're going to close on vendors. So why is this important? Everyone remembers several years ago, Target was hacked. There were hundreds of thousands of credit card records disclosed. I'm sorry, millions of customer credit cards were stolen. And that entry point was really Target's HVAC vendor. It wasn't really even Target. But they had an HVAC vendor that somehow had access to network systems, and that was how the bad guys got in. I don't know, for those of you in the nonprofit sector, you might be familiar with this Blackbaud incident. We got a lot of calls about that. Blackbaud is basically like a donor relations management tool, software tool that a lot of not-for-profits use to, communicate with, track donations, and all that. Well, Blackbaud had a ransomware incident where it appeared that their data was encrypted, and therefore donor information was not actually exposed, but it was a little unclear. And they paid the ransom, but they had really no way of getting a guarantee from the hackers that they would not otherwise sell the donor's information or any of that good stuff. So Blackbaud, I think, had determined basically that they did not have a technical breach under any of the statutes, but they provided notice to their customers that they had this incident. And it put the customers in a different, like our clients, in a difficult spot because they know of this incident now. They don't have all the information because it was a third party. But now they're in the spot of, well, do we notify our donors, and what do we tell them? And are we going to scare them off that they won't want to do business with us anymore? So your vendors can actually put you in a bit of a squeeze. And the point is that you don't have a whole lot of control over what they do on a day-to-day basis. You really need to have a written plan. This, again, the business folks are not going to be real happy about this because they want to find the right vendor that meets the business needs. But I'm just suggesting to you that you have a plan to include evaluating the quality of the security that the third parties deploy. It's got to be part of the consideration for what vendor you sign a contract with. There are some necessary legal clauses you want to look out for. What promises are they making about security? Are they warranting the level of security that they're going to keep your data safe? Is your contract silent? Is there a specific standard of care you want to put in there that they must meet X, Y, and Z criteria? Or are you going to have language like they're going to deploy reasonable security measures, whatever that means? There are obviously different levels of risk, but you just want to be mindful of that. Are they going to promise to have their systems, the security of their systems, verified by a third party? You might have heard of SOC 2 Type 2 audits. There are ISO audits. There are a lot of accrediting agencies out there that will go into companies, kick the tires on the system, and actually generate a report or certificate that they can provide to you to say, yes, we've had somebody independent come in and say, give us kind of the good housekeeping seal of approval. Indemnification is a big one. If there is a breach, are they going to actually cover your the fallout from that? Limits of liability is a big one. Many of these software contracts say something like, we're not responsible for any consequential damages or special damages. And oh, by the way, under no circumstance will we ever be liable to you for more than the amount of fees that you've paid us in the last 12 months, for example. And that may be a big number, but it may not be a big number. You may have suffered harm that greatly exceeds, the 15 grand in annual fees you paid to this vendor. One thing you want to be careful of is you want to make sure that whatever limits of liability you negotiate for, that the indemnification obligation is not subject to that limit. Are you going to require that they have cyber insurance? And if so, what kind, how much? And are you going to, there should be some language in there requiring them to report incidents to you so you learn about them immediately, even if it doesn't rise to the level of a breach under the statutes. You want to know about incidents, not just breaches. And then that's at the contract stage, but if you're doing business with these folks for 3 years, you need to have some mechanism to be able to monitor the ongoing compliance. Are they continuing to adhere to what they promised to do? All right, we are coming to the end. We got 2 questions in the Q&A that I'm going to tackle in a minute. So try to tackle in a minute. I haven't read them yet. If you have any questions, type them in now. And I am going to advance this is the information you have that you'll need for credits. So I'm going to leave this up while we're dealing with the questions. If you need to write any of this down or take a picture or whatever you need to do, please do that. So let me try to tackle some of the questions. We have one that says, our company had 2 employees that claimed Massachusetts unemployment. We notified Massachusetts unemployment and filled out the forms on Mass Fraud website. Is the company responsible for anything else? That's a good question. I have more experience with the sort of New Hampshire response than the Massachusetts, so I hope this carries over. And from what I've seen, particularly recently, the fraud investigators have been very slow to take any real action. Obviously, if you've got a form that comes back to you about an unemployment claim, you want to fill that out and notify and indicate that it was it's not a legitimate claim. We did talk about that if you've got a couple, maybe you have not risen to the level of needing to do your own investigation to make sure your systems are not compromised. But if you get a few more, or if there's some sort of disparate grouping, then you need to consider doing your own investigation. I gave you a slide there with some tips to give to your employees to help them protect themselves. So you might consider passing along that information to try to help them along. The next question says, on insurance, be sure third party is covered and review definition of devices to make sure it includes multiple devices. Yeah, that device point is particularly a good one. I'm glad you raised that. In the policies I've looked at recently, the definitions have been broad enough to extend to all devices utilized in connection with the business. So if you had, in other words, it's not necessarily the computers that are within the 4 walls of your business, but if you've got, a company laptop that somebody's using from home and it's used for company purposes, the way I've seen the policies described, I think generally speaking, that's covered. But again, the takeaway here is that these policies are not the same, and they're not uniform or standardized in the way your property and casualty policy might be. So you need to look at that carefully. And if you're going remote now long term, if you've seen the light and you don't need to lease space anymore and you want to go remote, make sure your policy matches the way you actually do business. I think that is it for questions, and we're coming right up to the 9:30 mark. This slide here is reiterates what Jim mentioned, that on March 10th, we have our next session, and it has to do with HR technology. So hopefully that's a good sort of segue into that. It'll be from 8:15 to 9:30 on March 10th. You can register the same way you did for this one. And I want to thank everyone for attending today. If you have any questions or follow-up, you can certainly contact us. We'd be happy to talk to you. And I hope everyone has a great rest of your day. Thank you very much.